Good afternoon, members. It is already 2:30 p.m. We've also formed a quorum, so I call to order the meeting of the Subcommittee on Overseas Lawyers Qualification for Admission Amendment Rules 2014 Commencement Notice. This is our first meeting. We need to elect a chairman. Any nominations? Mr. Abraham Sheikh, Dennis Kwok. Any seconder? Dr. Priscilla Leung. It appears that there can't be another candidate to be nominated. I accept. So if you accept, that's fine. So I declare that Mr. Dennis Kwok be elected as the chair.
Hi.
Hello.
好，咁我哋有請。我諗唔使選副主席。
I don't think we need to elect a deputy chairman. We've only got 1 hour for this meeting, and in fact, I have to leave at 3:30. So please invite the Law Society of Hong Kong to join us.
I know. 我知道，不過個 rules nothing controversial。個 rules 有冇咩 controversial？冇 ，just exam right？佢啲 exam 有冇得 apply for exemption？都可以。係幾時會可以？
其實有個 mark up for reference。Okay。做咗個 mark。
Are they coming?
Yes. They're here.
How am I用英文嘅？可唔可以用英文嘅？
可以。
Okay, well, welcome everyone from the Law Society. I've been informed that there is going to be no representatives from the Secretary for Justice today, but we'll soldier on nevertheless. We only have 1 hour today, so first of all, I'm going to invite representative of the Law Society to explain their position on this issue, and then we'll open the floor to the members. Thank you.
Thank you. Data press, that working? Good. My name's Dennis Brock. I chair the Foreign Lawyers Committee of the Law Society. Before you there are these amendments which are focused on, the only substantial amendment to our rules is to bring in a new and yet unnumbered Head 6, which would be the new constitutional exam. As you know, any foreign lawyer wanting to be admitted in Hong Kong has to go through the Overseas Lawyers Qualification exam, for which there are presently 5 heads. There will be an additional head on our Constitution. There are then 3 or 4 items of clarification, effectively codifying or memorialising what is already policy in relation to considering applications to sit the exam. The amendments were passed by LegCo, and the negative vetting period expired on the 28th of May this year. The only residual aspect is the commencement date, which we have proposed as 2nd of January 2015.
Thank you, Mr. Brock. Any other representative of Law Society would like to contribute? If no, then I'm going to open up the panel to the members of this committee. 議員有冇咩提問？
Members, any questions?
係，石議員。
Yes, Mr. Sheikh. I want to know when the syllabus can be drawn up and the entire package. You mean the timetable? Yes, please give us some ideas about the timetable.
既然佢講廣東話，不如我講。
Since he spoke in Cantonese, so I would take the floor. It's fine if you speak in English.
The only addition to the exam is the paper on Hong Kong constitutional law. And all the other examination, we have been holding it for how many years? 1995. Since 1995. So it's a 20 years practice. So there's the only addition is one additional paper, and I understand from the Secretariat of the Law Society that they have, in fact, lined up the panel for that paper, and invitation was sent out. So we are pretty sure that we'll be ready for the commencement in the coming January.
Thank you.
Other questions? Yes, James Toe.
Mr. Chairman, I recorded at a House Committee meeting, I raised the proposal to set up the subcommittee. Mr. Ronnie Tong raised his hand, but he is not on the membership list. Are you aware of the position? Yes, he'll ask me to ask questions on his behalf. I thought there wouldn't be enough members to form the subcommittee, so that's why I joined. So maybe you can ask the question on his behalf.
The questions that I have, since no other members have questions, is regarding the policy of overseas lawyers of the Law Society. The policy of the Law Society in granting exemptions in the past regarding papers, and also this new paper which will be introduced. What is the policy regarding possible exemptions, if any, if an applicant wishes to apply in the future, and who will set the syllabus? And I understand the panel of examiners will. Is it possible to give us some sort of indication or guidance on what sort of questions or what sort of topics will be examined under this heading? So, a couple of questions: exemptions, policy on overseas lawyers generally, and also actual examination topics under this heading.
That's for me, I guess. The gateway to being allowed to take the exam is 2 years. If an applicant has 5 years of experience, then they are eligible to seek exemption. Generally, if someone has, at least at present, if they had 5 years, they are automatically exempted from Head 2, which is litigation, effectively. Head 1 is conveyancing, and it is, in view of the fact that Hong Kong has a globally unique conveyancing system based upon a riding of Yorkshire's system in 1924, there is no possibility or prospect of anyone obtaining an exemption from conveyancing, so that's always sat. Head 3 is company commercial, which my friend John Chan looks after and makes sure that the candidates have adequate company commercial experience. It used to be the case that if you were a commercial litigator, that was probably good enough. We're somewhat more stringent now in wanting to see a proper level of commercial law awareness. Head 4 is accounts and ethics. Essentially, if you've taken a course and been passed in something which looks like our solicitors' accounts rules, then we're comfortable. So, put it bluntly, if you come from England or Australia or New Zealand or Canada and have passed the accounts course, that's fine. It's a combined paper with ethics, so the ethical standards are broadly similar. Some jurisdictions have bifurcated and don't have an accounts module, and that's been causing us some internal discussion. And I think we're moving to a point where unless your jurisdiction has an accounts module, you'll be required to take Head 4. The reason being is that the handling of client funds is very important, and an awareness of our solicitors' accounts rules is very important. So that's broadly the outline of how we approach the granting of exemptions. It's fair to say that we are, how will one put it, John, inclusive?
Yeah, if I may add something to what Dennis said. What Dennis said is about the applicant from a common law jurisdiction. So there's 5 years that previous experience in the practice of law. Such an applicant will be entitled for exemptions. But for lawyers from non-common law jurisdictions, normally we don't grant exemption, except the papers on the principal common law, which is an oral examination. If an applicant from a non-common law jurisdiction and he has set or passed, taken courses in the common law, like a master's in common law in the local university, then we will grant exemption to those non-common law jurisdiction lawyers. Otherwise, no exemption is granted to any non-common law jurisdiction lawyers. And for sitting exam, these lawyers from non-common law jurisdiction, we require them to have 5 years previous experience instead of 2 for the common law jurisdiction lawyers.
And that period of exemption or period of experience must be in the previous 10 years. Yeah. So if someone hasn't been practicing, if they've been farming for the past 10 years, then they are shut out.
So for someone who is from a non-common law jurisdiction but has taken something like the Master of Common Law program at, say, the Hong Kong U, he or she would be regarded as a common law lawyer who would be, or still a non-common law lawyer, but who would be qualified for exemption after 5 years?
No, if they apply as a civil lawyer, but they happen to have taken an academic course in common law, then we will consider the content of that course, and if it satisfies us that it matches the requirements, the 6 core topics of a common law subject of a common law exam, then we'll exempt them from the viva, which is head 5. One of these amendments is a tidying up amendment, which is if we had a slight anomaly in years gone by, which is if someone came from, say, typically the PRC, qualified in the PRC and then went to New York and qualified in New York, we took a first touch route, which meant your PRC, you have to be a civil lawyer. Now, there are many civil PRC lawyers who take the bar in China, go to New York, spend 20 years in New York, and then come to Hong Kong, and that was ludicrous. So we've now taken the view, as a matter of policy and now as a matter of rule change, that they can elect. So that PRC lawyer, or French lawyer, or Dutch lawyer, if they've got a common law qualification, they can then say that's my point of entry, and then they can seek exemptions under their common law qualification. But what I think, John, we don't give exemptions for academic common law success.
I see.
Well, the change is, apart from the additional paper of the constitutional law, the change this time is also that we give the applicant the choice to choose their jurisdiction if they are admitted in different jurisdictions. So in cases like if they are admitted in PRC and then they went to England or went to the US and got a common law jurisdiction qualification, then they can choose.
Obviously, the concern of the Hong Kong legal profession, I like to say and put this on record, is that although we run a so-called open jurisdiction, that we welcome and encourage the best lawyers from around the world to come and work here in Hong Kong. We also want to ensure that there are sufficient checks and balances and also sufficient qualification criteria that will be applied to assess whether a person is qualified to be a Hong Kong lawyer or indeed qualified for any exemptions. So for this head, what is your view on going forward? How about for this specific head? Is there any established sort of guidance or policy that you guys are thinking about in relation
well,
to
obviously
this?
it's new, and it's a paper that, in fact, I think was a creation of mine and Martin Rogers some 10 years ago, because we thought it important that lawyers had a grasp of our Constitution. It hasn't been set yet, but it's obviously going to focus on the basic law, and one assumes it'll focus on the cases we've had in the last 17 years where the courts have sought to interpret the basic law.
Mr. Leung, you just came in. Would you have a question? I have to follow the discussion first. Mr. Abraham Shak.
Someone's back here now. I don't have to keep you company. My question actually is quite simple. I understand that the Law Society is consulting on a examination for local lawyers, that people who actually graduated without attending the PCL. I think that was being discussed in this chamber last year. Now, there are a lot of frustrated law graduates who fail to gain admission to PCL by the 3 institutions. And those graduates, then if they go overseas and gain admission, having got their LLB or JD, whatever it is, having been qualified in overseas, can they come back and seek this what do you call this abstention from this 4 heads, because since they have studied law in Hong Kong and they well versed with the Constitution, do they still need that 5 years requirement?
The fact they've studied law in Hong Kong makes them eligible to be admitted in, say, England or Australia, but they apply for the exemption from the OLQE as being either an English or Australian lawyer. Where they took their first degree is not of our concern. We look at their place of qualification, and then they can seek exemption if they've gone through the gateways.
But the purpose of sitting for the heads for constitutional law, conveyancing, so they would have studied this in their undergraduate years. So why did they need to sit for examination again? Without the 5 years, because a lot of people, we do need, I like the openness of this profession, and different from the barristers. There's a closed shop, but you are actually opening the doors to attract more talents to Hong Kong, which is a financial commercial center of the world. So we need a lot of lawyers, and the very nature of the control by the 3 universities to debar people from entering into the lawyers' field, which is rather pathetic. So basically, this is a way out for people who have actually studied locally and passed the examination, because they don't want to be qualified overseas because of this archaic system of this control by the 3 universities, badly so. So they gain admissions overseas. And coming back to this, my question is very simple. They're well versed of all the heads of the different examinations. Why they need to sit for that examination if they have been less than 5 years experience?
Mr. Brock?
Now,
Mr. Lee, Chan.
2 points to clarify your questions. I still remember before I joined the legal profession, I was in the transport department. So they couldn't pass the exam here, the driving test. So they went overseas and get a license and come back to Hong Kong and change for Hong Kong driving license. So that's something it seems that you're talking about. But there is something different. One is that we recognize people's practice in law experience, not the academic qualification. So regardless of what they have studied, the basic requirements is that if they are common law jurisdiction, we need them to have practiced the law of his own jurisdiction for at least 2 years before he is allowed to sit the examination.
Yeah, right.
And for a non-common law jurisdiction, 5 years.
But the exemption.
So the second point is you talk about conveyancing paper. As far as I understand, in Hong Kong, you only study conveyancing when you are in the PCLL. But if you have completed PCLL, you don't need to take the overseas lawyers examination. You can just go straight to traineeship in Hong Kong.
But
so that's a different.
But the same logic applied, because if he had 5 year experience, he doesn't have Hong Kong conveyancing experience. You give them the exemption. Very likely.
No one gets exempted from conveyancing.
Okay.
Because there's no, as I said, and I think you may have missed it. The Hong Kong system of conveyancing is unique. It's based on a system in one of the ridings of Yorkshire in England from 1924, where they abandoned it, and then we've had 85 years of common law, Hong Kong common law. So there's no one coming from overseas.
I agree with you. I'm not making an argument. I'm making a case for the many, many frustrated graduates who were forced overseas, until you have that examination as proposed by the Law Society under consultation now, that they can come back and sit for that examination, that they can be qualified and then enter into the system. But we are forcing out a lot of young people out from Hong Kong into overseas for admissions. And I'm asking you to consider it as a special category of those people who want to make Hong Kong their home, who want to work in Hong Kong as a lawyer, and being deprived because of that three university. They took a lot of money encouraging people to study law, but not by admission of qualification, by admission of merit. A lot of local graduates were actually deprived of the chance to enter into the profession because they can't study PCL. So I'm totally in support of Law Society to start the thinking now, that which is under consultation on a examination, which I think is a very good thing for a lot of our young lawyers to be, you know. Sorry, I'm just considered about this specific case. It's very unique. We have churned out a lot of law graduates, but every year we limited the number of people into the profession, not by the Law Society, but by the three universities, which is not the purpose of university. I totally agree that the whole thing must be in the control of the Law Society for solicitors, but somehow this whole thing doesn't work that way. So if you could consider back, not for this particular ordinance, that those special category, if you can do something for them to help them to come back to Hong Kong. And that is a situation which I think is quite important. It's unrelated to this, but taking this opportunity.
Not completely unrelated, but a fair question, I believe. Mr. Brock?
Well, thank you for your comments. Good to know we've got another vote in favour of changing the system. As you rightly point out, it's beyond the remit of the Foreign Lawyers Committee, although the relationship is that if there were to be Law Society files introduced in Hong Kong, that would possibly eradicate the need for the Overseas Lawyers Qualification exam, because it would be a single point of entry.
Thank you.
Lang Yi.
Ms. Lang.
In fact, first of all, I have to declare interest. I have been teaching at City University Law School, but I do not teach PCLL. So a long time back, I have suggested the legal community to explore the possibility to have a common examination based on the fact that we truly have a number of good candidates who might not be able to go into PCLL. That is a fact, okay? So for that, I personally, and I know some other academics are open, in fact, worthwhile to explore. However, concerning whether examinations and this kind of additional conversion courses requirement is concerned, I truly think some of the courses are very unique for Hong Kong. I taught different kind of students from Europe, from other common laws, and also civil law system. So basic law, land law are very different. And then concerning actually, you list some other more general course from a point of view is contract law, tort, criminal, etc. We also have our own precedents now, because after handover, only Hong Kong precedents are binding to Hong Kong, and other common law jurisdictions are persuasive. So I have a question to ask is concerning 5D. 5D, because it is stated there that the period of pupillage cannot be recognized as post-admission experience. Do you mean that, in fact, to be barrister overseas, you know, in many jurisdictions like Singapore, New Zealand, actually there is fusion. The lawyers are both advocate and solicitor, right? So how I would like to know, or maybe you can clarify, does it mean that barrister pupillage is excluded as the eligibility criteria, or or just purely only the pupillage period? How about article clerkship?
I think you're talking about the description of how we define practice experience in the practice of law. So we've been counting article clerkship, traineeship, and legal practice course in lieu of training.
So the 2 years they counted. They count this 2 years article clerkship, but why
not pupillage?
Why?
Because it's different. It's a different branch. Because we are talking about practice experience in the practice of law for the purpose of overseas lawyers' qualification examination, which is targeted at solicitors.
Okay, so, Chairman, may I further?
Yes, please.
In many jurisdictions, solicitors and barristers, they now actually they have fusion. I'm just concerned, like, why you just exclude barrister or pupillage if they would like to take the same courses. In fact, I graduated from Hong Kong. I took PCLL in Hong Kong. So actually, it's just a matter of choice after we finish PCLL to choose whether we will take pupillage or article clerkship. In some other jurisdictions, I know actually they don't have such distinction nowadays. So are you only referring to whom? To UK or what?
Yeah, if for jurisdictions that have fused profession, then there is no distinction. So we'll count the period of training. But
so if they have no distinction, then they will count that year of training.
That's right, yes.
Okay.
Yes.
So which jurisdiction is in your mind? UK?
UK,
yes. Right? Many other common law jurisdictions are already no distinction between barrister and solicitor.
Yeah,
so
UK is one. Yeah.
Any more? Because you write it so explicitly.
Can't think of any.
Huh?
Can't think of any.
Okay.
Because
but even UK,
like Singapore,
already fusion.
Yeah.
You can be an advocate and a solicitor together.
Yeah.
So also, in fact, for this requirement of the duration of this, like for example, article clerkship. So you say common law jurisdiction, you only require 2 years. Non-common law jurisdiction, which cover China and civil law countries, then they need to have 5 years practicing experience. Does it include their, they might also have 1 or 2 year like training? Would it be counted also?
For the max 1 year training only.
Article clerkship also only count 1 year. I see. Yes.
Yes.
I thought it's only for the, unless the 1 year or 2 years, they are required for the admission into the foreign jurisdiction, then we will count them. So pupillage, for instance, if they are required as part of the admission requirement in that foreign jurisdiction to become a solicitor, then we will take care of it. We will consider that. But if it's kind of in addition to the admission requirement in whatever common law jurisdiction, is excluded. For instance, I'll just give you an example. In U.S., law school graduates, after admission, they would typically get a clerkship, right, with the Supreme Court, with whatever court. That will not be counted in here, because that's not part of the practice, unless we construe it as good enough practice of law.
That's exactly what...
Post-admission, yes.
Yes, Chairman.
No, okay, right.
That is exactly what I would like to ask, because some other jurisdiction, if you talk about civil law jurisdiction, the law graduate may directly enter the judiciary after taking a judge examination, qualification examination. Then they will receive judicial training. So will those people be counted? It's like they take the same lawyer's examination, then later on they will enter the judiciary. Will those years of experience be counted? Has it been seriously considered? Specific?
If it's pre-admission, as Dennis reminded me, if a pre-admission, for instance, in New York, is not counted because it's not part of the admission requirement.
Okay.
But if it's post-admission in New York, we would consider it whether, if it is good enough, practice of law as defined here. So it's practice of law, then we'll count it. But if it's not, then it's not counted.
So may I clarify from you, if a graduate, a law graduate from UK, they would like to go into the pupillage and then become a barrister, if they want to come back and choose this channel to become solicitor again, then both privilege and their practice as a barrister will not be counted. Am I correct?
No, the practice of barrister will be counted.
Will be counted. So they can actually, it may be a switch, miracle, for those young barristers to come back to be a solicitor in Hong Kong if they have proven experience practicing.
They have to sit exams.
Yeah, of course, they have to sit exam. But they still need to take all those courses, right?
Yeah. Except the common law if they are barrister.
Huh? Yes? Sorry, I can't hear you.
Except the paper on common law.
The viva.
Yeah.
Except the paper on common law, they are exempted, you mean? Yeah.
If they're, okay, the hypothetical English barrister,
yeah.
right, barrister from England and Wales with 5 years experience would be, first of all, because he comes from England and Wales, he's exempted from the common law viva. So he then has, at the moment, 4, and then next year will be 5 exams. And if he goes through the various gateways of 5 years in the practice of law, he will be eligible at present to be exempted from procedure. Typically, barristers don't get exempted from accounts and ethics because they don't do a solicitor's accounts rules in England. Obviously, they have to do conveyancing. Commercial is whether they can demonstrate adequate knowledge of commercial law. We don't treat them any differently. The fact they come from the barrister's branch or the solicitor's branch in England or wherever is irrelevant. It's what they've been practicing in their home jurisdiction, and indeed what they've been practicing here. If they come here and register as a registered foreign lawyer, we give them credit.
Oh, sorry, Chairman.
Yes.
I got some confusion. You just mentioned again 5 years practicing experience, but from what we are aware of, we are mentioning graduate and also relevant common law experience is only 2 years. So
exemptions 5.
Exemptions is 5. Gateway is 2. You need to,
okay,
so a barrister coming from England has got to wait 2 years because in order to catch up with a solicitor from England who's done 2 years articles, or what are they, training contract. So the 2 kids who go to law school the same day in England, they can come to Hong Kong on broadly the same day and sit the exam.
Okay.
Now, if that person happens to be a Hong Kong graduate and went to England and spent 10 years at Freshfields in London, then he can come back and get exempted and sit the OLQE and requalify in Hong Kong. We don't treat them any differently.
So he can get the exemption of courses.
Yeah, exactly. I think in a broad statement, we expect the foreign jurisdictions, when they admit people in those common law jurisdictions, to have satisfied themselves as to the academic component of the admission. We don't delve into what they studied at university.
Is that clear? No, you.
Any questions?
Required courses are taken care by the Law Society.
Say again?
All these required courses are taken care by the Law Society, right?
There are professional providers that provide the course.
So there will be a bundle of materials and they will have syllabus, etc.
We have a set syllabus. We provide the syllabus. We don't provide courses. So we have commercial providers in the market to do that.
Maybe there's some confusion here, I think.
Yeah.
We are dealing with foreign lawyers only, those lawyers who have been admitted overseas, not in Hong Kong. Okay, Hong Kong, they can go through PCLL and they can automatically get into the legal profession. But then we are talking about these foreign lawyers who studied overseas and become lawyers overseas. They come to Hong Kong, they want to become Hong Kong lawyers. Yeah. So we don't really offer them courses. we decide whether they should sit all 5 exams or they can sit just one. That's what we do. That's what the committee does. And then in order to determine whether that person should take 5 or take 2, we look at their practice. If they had 5 years of practice of law, and that's very qualitative, in addition to quantitative, and then we use the syllabus to judge, to a certain extent, whether that person has been exposed to these different areas of law, as would a Hong Kong solicitor be required to be exposed to over in the law school or in the PCLL, or during the 2 years of training.
So actually they can do self-studies.
You can.
Just take the examination.
Yeah.
They can be taken online. They can study overseas if they wish. They don't need to be here to do it. They have to take the exam here, but they can study overseas.
In a way, we are trying to create a kind of a fair, to a certain extent, right? It's a fairness for us, treating foreign, since we are inviting foreign lawyers to come to practice Hong Kong law. So we want to be kind to them, and we want to set a standard. So that's basically the standard that's been set over the past many, many years. Unless you want to set a higher bar, that would be a different issue, right? Somebody, another gentleman mentioned earlier, I come from New York. I passed New York bar. I'm from China, actually, but I passed New York bar. But New York is different. Anybody has to take an exam, okay, 26 subjects at a time. So you have to go through the Barbary or whatever review courses, and then you take it. But then you must have one common law education, like 1 year. So you take a LLM 1 year, then you are qualified. If you just fresh from China without any common law education and you want to sit that exam, no. But if you come from Hong Kong, yes, you can. From Hong Kong U law school, and you want to sit the New York exam, yes, you can, because it's a common law jurisdiction. So for New York, it's only that 1 year education that counts. Otherwise, everybody goes through the examination. But then there's no training, 2 year training, there's no PCLL, that kind of stuff. It's different.
Yeah, Chairman. Actually, just to do fairness to the requirement of these courses, because I'm aware and I also support to require those courses, because especially conveyancing and basic law, constitutional law are totally different. And like you say, in New York bar or California bar, actually you take a master course there, then you can take the exam. Yes, but in Hong Kong, the students really have to complete 4 years undergrad, if we don't talk about JD, and then 1 year PCLL in order to be qualified. Right. So we do have very serious and intensive training for the law graduates. So I think it is fair. Otherwise, it will become a shortcut for those who are not qualified to enter our law schools in Hong Kong, and then they just get that trend. And then they come back a very easy route. So, in fact, I would like to see standards. My suggestion is we should see standard. I mean, at least if they want to practice in Hong Kong, they should meet our standard.
Agree.
Well, we agree, and that's what we do. Yeah. I think today's discussion is focusing on one issue, which is the commencement date. So unless there's any more questions relating to commencement date.
Well, this is related, so they are entitled to ask questions. I wonder. I see.
Well, I'm not sure. Is that right? Are they related? I mean, we're talking about the substance of the exam.
Yes.
The exam has been approved by LegCo.
So LegCo members are entitled, and indeed it is their duty to ask questions. I see that there's another member, Mr. Porte. Otherwise, if you have no further questions, I intend to draw this meeting to a close, if there are no further issues.
No, I don't have any further questions, Chair.
Thank you. Is there anything else?
Do you want to it's 因為我哋嗰個scrutiny period 咧就去到19號嘅，如果我哋19號咧就要呢個禮拜5去 house， 咁我就未必可以做得起。
今日下個禮拜先。
咁我哋 extend the scrutiny period until December 10th， 咁你可能下個禮拜 house to move。
各位議員 頭先秘書就同我講，佢就
Members, just now the clerk told me that if we would like to report to the House Committee this Friday, we may not have sufficient time. So maybe next Friday next week, I would give a report to the House on your behalf. But in that case, we need to extend the scrutiny period. In other words, at the LegCo meeting next week, I would move a motion to extend the scrutiny period.
佢冇 comment。
唔係啊，即係譬如 report，即係譬如啱啱你
今日禮拜二。
係啊，咁我哋最遲禮拜4會出到個 report。
OK。
即係後日，咁應該就未必咁遲。
OK。
Well, the clerk is worried that maybe we can't beat the deadline, so please try your best. If we can, then maybe we can send a draft copy of the report to the Law Society. If we can beat the deadline, then on Friday this week I'm going to report to House Committee. Only when we can't beat the deadline, then next Wednesday we are going to move a motion to extend the scrutiny period. Well, for the agenda of the LegCo meetings, I think it's quite uncertain. I'm not quite sure whether we can extend the scrutiny period. All right, that be it. If you don't have other questions or comments, legal advisor, anything to add? All right, thank you very much for coming. Thank you. And on behalf of this subcommittee, I will give a report to the House meeting agenda.